Hi, everyone, and welcome back to our third and final day at HT Next. I hope that you've been enjoying not only opportunity to connect with your colleagues, but a lot of great content that we've been thrilled to produce and bring to everyone here at the event. We have a great day lined up, 3 more fantastic sessions today and a little bit more time for networking. So we encourage you to hang with us and take full advantage of the platform. We're going to get started in just a moment here with this morning's or this afternoon's or this evening's opening session, depending on where you're located. We're going to get started with our opening session. Our session today is a really important topic. It's going to be focused around 5 privacy issues that hotels should be addressing as soon as possible. This session is going to be delivered by a really good friend of the hospitality technology brand, Odia Kagan. Odia is the partner and chair of GDPR compliance and international policy with Fox Rothschild, and she has been a fantastic resource for us over the course of the last year, providing a tremendous amount of education around privacy and various legal issues tied to consumer privacy. So Odia is going to deliver some presentation materials first, and then she's got plenty of time for Q&A at the end of her session. We have found that when we bring Odia to the audience, there's a lot of questions. So as you start to think of your questions, you can go ahead and type them right into this browser here, and we'll be monitoring those throughout the session. And then we'll move to Q&A in about 20 minutes or so, live Q&A with Odia, and she'll be here to answer all of your questions. Really excited to get started, and with that, we're going to kick off the show.
Hello, I'm Odia Kagan. I'm a partner and chair of GDPR Compliance and International Privacy at Fox Rothschild, a national US-based law firm. In my day-to-day, I help hotels and hospitality companies, technology companies, work through their products and services and make sure that they're doing what they need to do in order for those products and services to be compliant with data protection laws such as CCPA, GDPR, the new California Privacy Rights Act, etc. Today, I'm going to discuss with you 5 issues that hotels are facing and should address in the rest of this year, 2020, or in the next year. So, question number 1. What are some common mistakes relating to your privacy notice under the California Consumer Privacy Act? So, California Consumer Privacy Act. This is the first comprehensive privacy law that is legislated in the U.S. that governs how companies handle personal information that identifies residents of the state of California. One thing that is different regarding CCPA and your normal privacy notices that we were used to having is the fact that the old privacy notices were only about the information that you were collecting on your website. And this is no longer the case. CCPA requires you to, and you should make sure that your privacy notices disclose all of the information that you are collecting, not only on your website, but also at the registration desk, at the online booking agencies, at the contactless apps, marketing, lead generation, events, conferences. So any information that you are collecting in any medium belongs on your privacy notice. That's number 1. Number 2, you want to be really specific. So the days of, having very vague statements about what information you may be collecting, those are gone. So you need to be really specific about what is the information that you are collecting. Why are you collecting it? Who are you sharing it with? Why are you sharing it with? Where are you getting this information? All of this needs to go into your privacy notice, and you want to disclose it in a way that a normal person, a guest, would understand. So the language needs to be really clear. You want to get away from legalese. You want to also be on top of who are your service providers, like what is the data sharing that you're sharing, and I'm going to talk about that in a second. One final point about your privacy notice to remember is you need to have one for your California employees or applicants. CCPA protects and gives rights to California consumers. California consumers are actually residents of the state of California. Employees, pursuant to a recent amendment, and now with the California Privacy Rights Act having passed, and I'll talk about it in a second, the rights of employees to get a copy of their information, to have their information deleted, those rights that California consumers get were carved out. So employees do not have these rights until 2023. But they do get to have their own privacy disclosure of what is the information collected about them, and where is it coming from, and what are you doing with it. So that's something to keep in mind for your employees. Question number 2. What is the deal with the do not sell my personal information link, and what should I be thinking about? So what is the do not sell my personal information link? This is a hyperlink that needs to be on your website that says do not sell my personal information, and it needs to lead to a place where the California consumer should be able to exercise his or her right to prevent a sale. What is a sale of personal information? A sale doesn't just mean when you exchange personal information for money. It also means exchanging personal information for other valuable consideration. This can be some value add that you get from allowing, let's say, a third-party cookie analytics provider, targeted advertising provider, get the information of your guests, website visitors, and in consideration you get crunched data, you get more eyeballs, you get more advertising, etc. So this could be a sale. People have the right to opt out of this sale under CCPA. So what does this actually mean? Number one, when in doubt about the do not sell my personal information link, think again and consider it. This is a priority of the Attorney General's enforcement, and indeed we have already seen the Attorney General start this enforcement actually on the very day that CCPA became enforceable. This is July 1st. The Attorney General sent out enforcement actions, and they have in part dealt with this do not sell my personal information button. So cookies are something to think about even in the US. They are now a big deal in Europe. As those of you that are involved in international chains know, they are now something to look at in the US as well. The other thing to think about with respect to the do not sell is looking at your data sharing. You want to make sure that you are classifying your third parties that you are sharing data with correctly. Are they a service provider? Meaning they are a party that you share personal information with in order for them to give you a certain service where they are doing it for you? Or are they a third party, which means that they also do it for themselves, they get a value add out of it for themselves? If they are a service provider, sharing the information with them will not constitute a sale, will not trigger the requirement to have a do not sell and a do not sell right. On the other hand, if they are a third party, this could be a sale, and then you would need to operationalize this do not sell situation. The other thing to remember is when you are designing this, your do not sell, your sale opt-out process, or indeed the methods for exercising your consumer rights under CCPA, right? People have the right to get a copy of their data. People have the right to have their data deleted. And you usually have methods, online forms, in order to facilitate the exercise of these rights. When you do that, you want to make sure that you are refraining for something called dark patterns. Dark patterns is a situation where you design your website in a way that is intended to influence the behavior of the individual. So yes, I'd like to get a copy of your newsletter. No, I'd like to die dumb. Under the new regulations, a proposed amendment by the California Attorney General This is something that they are looking at and was basically removed and re-added. So this is something that the Attorney General is taking a look at. So you want to make sure that you are being very helpful to people in allowing them to exercise their rights. It shouldn't be hard for them to do. Question number 3. What is CPRA, and what are the 5 top things to start thinking about? So CPRA is the California Privacy Rights Act. This is an amendment to CCPA that was passed as a ballot initiative in the recent elections in November. This basically means that from now on, any further amendments to CCPA are going to be more difficult because they need to be done. They can't just easily be done by the legislature. This also means that starting with CPRA, California is going to have its own data protection authority, its own enforcement agency that is dedicated to the enforcement of data protection violations, which of course raises the stakes. What are key changes? Now, CPRA goes into effect in 2023, but what are things that are worthwhile looking into now because they are important and also require time and effort to put into place? Number 1, data minimization. What does that mean? That means usually having a conversation with the marketing folks and seeing what information that you are collecting do you actually need. Do you need a full date of birth? Do you need a full social security number? Do you need a full middle name? Do you need to take this passport number? All of that. These are questions you want to look at because you want to make sure that you have a good reason for all of the information that you're collecting up front. Secondly, you want to also have a good reason to hold on to the information that you have collected. CPRA introduces a GDPR concept that you are not allowed to retain information for longer than the time necessary for the purpose that it was collected in the first place. So, if you needed a passport in order to, confirm identity or travel, if you need a credit card in order to facilitate payment, do you still need them, right? It is very important to look at this and basically have a mapping of all of your information, especially sensitive information like passport numbers, driver's licenses, social security numbers, and make sure that you're not holding on to old information. The reason is, number 1, this is now going to be an independent legal requirement under CPRA. And we know that there is a similar independent legal requirement under GDPR, and that is already being enforced. The other reason that this is a good idea is that it takes a lot of time and effort and discussions to figure out all of the information that you have, how long you are keeping it and why, and getting to an agreed schedule of deletion that everybody can agree on. And the third reason is that this information, holding on to information that you no longer need, is actually an exposure, a risk factor even now. Because number 1, a lot of this information, the sensitive information, is breach reportable under the existing data breach notification laws of the United States. So if you have an incident, and as we know, data breach incidents are not uncommon in the hotel industry, you can be liable, you can be open to class action lawsuits, PR exposure, etc. And so that is, those are the reasons why it's a good idea. It's also a good idea in the process to understand where all the sensitive information is because CPRA gives additional rights to people in those sensitive information. 2 more things to think about. Number 1, profiling. When you look at somebody's characteristics, travel history, booking history, spa visits, loyalty program information, You want a browsing history and leads that you got. When you take all of these things and make determinations with respect to marketing, with respect to discounts, with respect to comps and things like that, that can be profiling. And similar to GDPR, CPRA is going to impose new obligations regarding profiling. Also important to remember that loyalty programs, membership rewards, those could also be financial incentives under CCPA as it exists today. And if they are, they require an additional disclosure as well as an analysis of the relationship between the value of the data that you get from people and the value of the discount. So that's also something to keep in mind. Number 5 and last with respect to CPRA is a DPIA, a data protection impact assessment, which is basically a risk assessment that you are supposed to carry out regarding particularly risky types of operations if you have them. So that's also something to keep in mind. Question number 4. What is the FTC looking at? So we talked about CCPA, we talked about CPRA, but the Federal Trade Commission is actually the de facto privacy enforcer in the United States. And so it's really important to look at what they are kind of paying attention to, as we can see from their recent enforcement actions. So in one word, governance. In 3 words, governance, governance, governance. FTC is looking at the structure and the formality of what companies have in place as an attestation to how well prepared they are, especially in a security incident or a data breach. So they are looking at, do you have somebody who is in charge of the compliance, the security, the privacy? Do you have a process? Do you have written, documented, tested, regularly reviewed policies and procedures regarding information security, regarding data breach? Do you have a risk assessment program? Do you have a good process for vendor management? Vetting vendors, agreements with vendors. As we all know, the vendors are usually the kind of more sensitive spot and also have been in data breaches in the hotel industry. So that's very important to look at. Finally, a question from the audience. And if, by the way, if you have questions after the live Q&A session that we're going to have shortly, please don't hesitate. You can contact me, connect with me on LinkedIn, or send me separate questions. I would be happy to hear from you. 5th question is regarding GDPR. What is the impact that global hotels are likely to global hotels that are likely sharing data illegally vis-a-vis the illegal transfer of data from the EU to the US and Privacy Shield? All right, so first of all, Privacy Shield in the Schrems II case. So a couple of months ago, the highest court in Europe, the Court of Justice of the EU, issued a decision called Schrems II that basically changed the way that cross-border transfers of information from the EU to the US are done. Under GDPR, when you transfer personal information, personal data of people from the EU to the US, which is considered to be a country that does not protect information adequately or at the same level as Europe, you need an extra mechanism. One of these mechanisms was Privacy Shield. It was a self-certification program with the Department of Commerce. The companies had to self-certify, and then you could transfer. The Court of Justice of the EU in Schrems II invalidated this and said transfers can no longer be done under Privacy Shield. The other mechanism that was used, which are the standard contractual clauses, this is basically like boilerplate language that was added to the transfer agreements. The court said, okay, well, standard clauses, they are still okay as a mechanism, but they may not be enough when you are transferring to the US, because in the US, there is particularly invasive surveillance by the government authorities like the NSA. And so what's a hotel to do? So the first thing to say is, we are, at the moment of recording this, we are still waiting for guidance from the European regulators, the European Data Protection Board and the European Commission, with respect to what is this extra, these supplemental mechanisms or provisions that we can add in order to still allow a transfer to the US. And so if I have new information on this, I will be telling you this shortly in the Q&A section. But what can you do other than wait for this word from Europe? So the first thing that we know we need to do is map out all of the transfers. Look at all of the transfers of personal data that you are carrying out from the EU to the US. This speaks specifically to entity transfers. So these are international hotel chains that transfer HR data or guest data. When you are a US-based hotel collecting information directly from a European-based customer that is just going on your website, that is a direct transfer, which is going to be easier to do and not really affected by Schrems. So map all of your transfers. Where is data going? Are you using any service providers for this? Are your service providers using any other service providers? You want to go all the way downstream and assess, what is the information? What is the purpose of the processing? Where is this carried out? So you have a US-based provider. Do they have all of their subcontractors in the US, or is information somehow going somewhere else like China? Then you want to figure out whether or not these providers are subject to the U.S. surveillance laws, FISA 702, Executive Order 12333. If they are, you want to try to figure out how you can mitigate the risk. First of all, HR data, for example, may be less sensitive from a surveillance perspective than guest data. You want to see whether your providers have government transparency reports. How often do they receive requests? What have they done with these requests? Can they report to you when they receive these requests? Can you minimize transfers? Are there transfers that are not necessary? Can you do some information by transfer in the aggregate, pseudonymizing the information? And so you do the mapping, do the assessment of the risk of the transfer, and then wait for word as to what are going to be these supplemental measures that we can add into our agreements in order to facilitate the transfers. I look forward to the Q&A session and to speaking with you. Thank you very much. Hi. So we have a lot of questions that have come in, and I'm going to try to address them, but I want to make two comments first. First of all, hi, everybody. I'm really happy to be here and do the Q&A. I want to update you because, as you saw in the recording, I said that this is recorded at a time where we still don't have guidance from the EU. So now we have guidance from the EU. In the couple of weeks from the time of the recording until now, we got guidelines from the key European regulator, the European Data Protection Board, and we got draft standard contractual clauses from the European Commission. What does that mean from the practical advice that I gave in the recording? Actually, it didn't change much of what companies should start doing. And here is the reason why. The guidelines that came out, they are draft guidelines for public consultation. They had they laid out, and if anybody is interested in, I wrote a short piece that lays out these steps. If you want to contact me or to connect with me on LinkedIn, I'm happy to share the information. The EDPB laid out 6 steps of what to do. The first was mapping the transfers, as I had suggested. And the second is looking at how you transfer and what is the transfer mechanism. And then trying to see if you can replace it with a different mechanism. The problem is that what the EDPB said in the draft guidelines is that there are a few use cases where transfers to the US are just not possible. right? They said you can have different language in the contract, you can have technical measures like encryption, but sometimes because of how FISA 702 works, sometimes it's just not possible at all. And that is obviously a statement that's very problematic for cross-border transfers. Hopefully, this will get somewhat amended in the final draft and shift to a more risk-based approach. Right now, with that in mind, the only options are, after mapping your data, is to try to figure out, one, can I minimize the transfer? And two, can I, or just not have a transfer if possible? And two, what are my options to minimize the risk? Because that's really, that might not be completely compliant with the current guidelines, but that's kind of all we have. So that's the update. And I'm happy to share more information because it's a lot to share in like 2 minutes. So now let me go through some of the questions. When leaving, with the UK leaving Europe this year, what should UK hoteliers be doing now to allow them to continue receiving data from European countries? And what happens if they don't have this in time? So this is kind of directly related to this, to the last comment. The UK leaving Europe, it really depends. Now we're almost out of time, but if there is an agreement in place by the 31st that addresses data transfers and recognizes the UK as a country which is adequate, provides adequate protection, then there's no issue because you can just freely transfer. If, however, the UK is not granted adequacy and it is then deemed a third country, then the cross-border transfer of data from the EU to the UK is basically similar to the transfer from Europe to the US, minus the fact that, unlike the US, there is no court of justice judgment that kind of really digs into the surveillance practices and says that transfers cannot be cured. And so what you would need to do is you would need to put in place cross-border transfer mechanisms. These are standard contractual clauses of the kind that we already have in place if these are normal EU to UK transfers. And that's actually what companies in the UK are kind of scrambling to do right now. What is the likelihood of CCPA becoming a US national standard, or is every state going to develop its own consumer privacy protection? So I think that we have a lot of kind of momentum for a federal privacy law, but I don't think that it is imminent. Because, and not because of differing opinions with respect to the key aspects, the core issues, but rather with respect to kind of related issues, which is, should there be a private right of action, meaning should people be able to sue? And should a federal law be a ceiling or a threshold, right? Should there be preemption? And because there is such a strong difference of opinion between the two parties about that, that makes it difficult to see a federal privacy law in the works in the near term. And therefore, we should expect different states to have different laws. Washington revived its Privacy Act for the third time, and we should expect to see other states coming soon. So with this, I think we're out of time, and I would like to welcome back Abby Lorden from HD Next to continue to the next bit. I would be happy to hear from you, and I will follow up with the individuals that asked the questions also personally. Thank you.
Fantastic, Odia. Thank you so much. What a great download of information. And we've captured the questions, and we know who you are, that you submitted questions to Odia so that we can follow up with you. We can make sure that she's able to follow up with you to answer any questions that you might have had that we weren't able to address. So we're going to move quickly to our next segment that's going to start here in just a few minutes. It's our IT leadership panel, which is always a really popular segment at HT Next, and it features several great brands, including Choice Hotels, G6, and Edwardian Hotels. We're really excited for that segment. We'll do one more networking break. That will be at 2 o'clock Eastern. We'll do one more networking break at that time, and then we'll all come back to the auditorium at 2:15 Eastern for an industry wrap up an industry overview that includes speakers from STR, the American Hotel and Lodging Association, and then we'll come back for closing comments all in that chunk of time. So at this point in time, we're going to move into our next session. It will begin in just a few minutes at 1:35 Eastern, the IT Leadership Panel. It does happen here in the auditorium. When I'm done here, this segment will close, and then you go back to the content box there to open up that window and find the next session. That is the IT Leadership Panel, and that will become available at 1:35 Eastern in just a few minutes. And with that, ladies and gentlemen, we're going to keep moving right along here. Thank you.